Hi, I'm John Myrna, and welcome to tonight's iStreaming event. The topic tonight is the Insider's Guide to the Bankruptcy Process, and this is sponsored by the Myrna Law Group. So welcome once again. There's a few things I wanted to accomplish tonight, and the first one is I just wanted to lay out a map of what the process is going to be like. If you're like me, understanding what you're getting into will relieve the stress. And so this is really just a superficial map of the process, some of the things you can do to make it less stressful and give you a better understanding of how you can help and make the process work for you. The first thing at the beginning of the process before you've done anything is, of course, you're trying to figure out what to prepare for before you go in to see an attorney. And so there's three things I want you to get together. First thing is you've got to get the bills together. And there's two types of bills. There's the household bills where you have the expenses of what you're paying for utilities, food, etc. Those are bills that basically are going to allow the attorney to analyze your income and expenses. But then there are the bills that are causing you the stress. The credit card bills, primarily unsecured debt, whether it's credit cards, personal loans, your car payment, your house payment, no matter what you're going on, they kind of fall in both categories. So you need to get your bills together so the attorney could understand, separate them out into the household bills versus the debt that you're trying to deal with. The other thing that you really need to understand before you walk into the attorney's office is very helpful for us is your income. A lot of people, know what they have coming in the bank every month, but they don't know what they really make. So you need to know what you make before taxes and after taxes, whether it's on a weekly, bi-weekly basis or a monthly basis. So the before and after tax amount, that's very, very helpful for the attorney. It'll allow us to understand your actual income a lot quicker. So that's what you need before you walk in the office. The next thing is, okay, step 2 in the process is to meet with the attorney. So what you want to do first is you want to call at least 3 attorneys. You want to interview at least 3 attorneys because there's several things that you want to understand about the person you're going to choose to represent you to do your bankruptcy. First thing is you want to find out if that person has an interest in your case. A lot of attorneys will give you consultations, but if you feel like you're rushed and you're in and out, chances are that's how you're going to feel throughout the process. So you want to get a feel for the attorney. Is he interested in my case, and will that interest continue even after I walk out the door? The second thing is, can he accommodate me? Does he provide a payment plan? Is he going to work with me with regards to getting the case filed? Is he clearly laying out what it is I have to do and wants me to do as my part of the process? Does he stress recovery? Remember, recovery is the goal here. It's not the bankruptcy. The bankruptcy is just the process of getting to the recovery goal, but the recovery is the goal. If the attorney's not stressing recovery or giving you any information on recovery, chances are, he's just putting a patch on your problem, and he's not going to help you get to the ultimate goal, which is for you to get your credit back and to be able to buy the house, the car, whatever it is in the future that you're looking to get. So as you go through, interview 3 attorneys, get a feel for them, and feel is the best way to quantify it. If you feel comfortable with them, chances are they may be good. If you don't feel comfortable, chances are you're overpaying no matter what they're asking. Now we've gotten to the next phase. The next phase in the case is making your decision. And the attorney is going to work with you on what you're going to do in terms of the bankruptcy, whether it's a Chapter 7 liquidation or a Chapter 13 reorganization. Those are the 2 most common cases that apply to debtors, individuals with regard to dealing with their debt. The Chapter 7 is where you eliminate your unsecured debt. Unsecured debt is like credit cards, personal loans, anything that's quote-unquote unsecured. Secured, it's easier for me to define unsecured by just telling you what the definition of secured is. Secured is where there's a lien on a property, whether it's a car, you have a security interest in a car, and that's what a car loan is, a lien on a house that has a security interest. There are also certain types of liens that are a little less formal. They're personal purchase money security interests, such as if you go to Best Buy and you buy a television and you finance it through Best Buy, they have an interest in that television, and that's a pseudo-secured item. So the bottom line is that you need to get all of your bills together, and he's going to help you analyze what it is you're really trying to accomplish. Is it just eliminating debt to free up cash flow so you're not paying on it, to protect you from your creditors, or do you need some sort of reorganization, which is the Chapter 13? And a Chapter 13 reorganization, just real general, basically is where you take a debt, whatever the debt is. It could be that you're behind on your house, it could be some tax debt that you can't otherwise get rid of and you want to repay, and you repay it over a 3 to 5 year repayment plan. So the attorney is going to help you figure out which of the 2 types of bankruptcies will help you. So that's kind of the second phase. The third phase is you hire the attorney. And basically, you're going to collect up your documents. The attorney's going to help you a lot with that. He's going to basically give you the checklist of documents that are required. Those documents include, and I'll just go over them generally, they're easy documents you have. They're your tax returns for the last 2 years. If you haven't filed your taxes, you're going to have to get them filed. And that's state and federal with your W-2s. They're your pay stubs. They're going to ask you for the last 6 months of pay stubs, so start collecting them, hold on to them, don't get rid of them. They're going to ask you for some titles to your vehicles, registrations, just to see how they're titled. You'll also have to provide the deed for your house, any mortgage statements, and there's a few other more minor items that you're going to need, but you will have to start collecting them. Any attorney you go to will give you a checklist. Ours is on our website, but the bottom line is that you've got to collect up the documents as you get through the process. All right, so let's assume you've gotten to that point. You've collected all your documents. You've done your credit counseling certificate, which is part of the process. Let me explain that real quick because, like I said, I might oversimplify, but to file any bankruptcy nowadays, you have to file 2 certificates. One prior to filing, a credit counseling certificate. It's good for 6 months, so if you do it and you're not planning to file right away, you need to make sure you time it or you'll have to retake it. And then after you file, you have to do a second certificate. It's a financial management certificate or a debtor education certificate. That has to be done before your case discharges. We generally ask you to do it within 30 days just so we get it out of the way, because if you forget to do it, it can be almost terminal to your case, meaning that they can basically close your case without the discharge. So those are 2 important documents you're going to have to get in the process. All right, so now we're down to the process of your filing. All right, you filed your case. Now I'm lumping Chapter 13 process and Chapter 7 processes together right now because in the first 30 days, from the time you file to the time of the meeting, it's pretty much the same. You're just preparing to go to the meeting. In Chapter 7, you're wiping out debt, so in 30 days you're going to meet with a trustee. He's going to look over the paperwork. There's 3 things he's going to look for. One is, do you qualify? That's what your attorney is supposed to look at and make sure you do. Number 2, is there any fraud related to the debt? Meaning that, is there something that occurred? I'm sure that's fine, and your attorney will advise you if there's any problems at all and show you how to fix them. And number 3, is there any assets that the trustee can take? And once again, that's the attorney's job to make sure that he analyzes all of your property to show you how it's protected and how it can be protected. So those are the 3 big considerations that you're prepping for in a Chapter 7 and that the trustee is going to be looking at when you appear in that hearing 30 days to 45 days after you file. In a Chapter 13, once again, the hearing's about the same time. The assessment's a little different. You have filed a repayment plan, whether you're catching up on your house or paying some other debt. The trustee at that hearing, his focus is primarily on 3 things. Is the plan feasible? Meaning, can you really afford to do what's going on? Does the plan meet the requirements of the bankruptcy code on how you pay your certain creditors? So he's looking at your case from that perspective. Can you do it? And is it done correctly? And in both cases, just to relieve your stress a little more, no real decisions made at that hearing. That's really just a fact-gathering hearing. It's a very stressful time for all of our clients and anybody going through bankruptcy because they feel like that's when everything's happening, and it's really important that they convince the trustee to do what, to give them the discharge. But it doesn't really happen that way. The bottom line is they're just doing their fact-finding. And after that, if there's any issues, they're going to work it out with the attorney, your attorney. After the hearing in Chapter 7, there's 3 things that go on. Number 1, it's about 60 days until you get your discharge after Chapter 7. So from the time you file to the hearing, it's 30. After the hearing, it's another 60. In that 60 days, you've got to if you have a vehicle with a loan on it, you've got to do a reaffirmation on, get that reaffirmation executed and back. And what the reaffirmation does is it just reobligates you on the loan, should you decide you want to keep it. And it basically also helps because it restarts them reporting on your credit. So as long as you stay current, it's going to help you rebuild your credit. The other thing you've got to do is you've got to do the credit counseling, the second financial management or debtor management course by the time you're filed. So you've got to sit down and get that into your attorney so he can log it with the court to make sure that they know you've complied with all those requirements. So those are the big things in a Chapter 7 that occur. Then after the 60 days after the hearing, you get your discharge. It's automatic at that point. In Chapter 13 is a little different. After the hearing, your plan is in a phase basically where a creditor has the right to object. If there's any issues with how you're presenting your repayment plan, and any creditor wants to object, they can object during that period. It's not, while the word objection almost sounds, very, intimidating, it's not. The bottom line is it's just the process of working out the correct plan and the way that the creditors are going to be handled. So objections, sometimes they don't come at all, sometimes they do, but the bottom line, they can be worked out. And 30 to 60 days from the hearing is the confirmation hearing. Now, if there's no objections, there's no confirmation hearing. You don't have to attend, it automatically confirms. If there is an objection, most of the times with most attorneys, that objection is worked out. The hearing is extended for another period of time for any creditors to object. So there's another confirmation hearing time set. And once again, if the plan is correct at that point and no further objections, then the confirmation goes through and boom, you're off and running with your repayment plan over the 3 to 5 year period or however you want to do it. So that's the most I want to talk about, the detail of the process inside the bankruptcy, because the bottom line is it can be very complicated and your personal situation can affect how it's actually going to operate. But for the most part, that's what you're going to experience in the timeline. And those are the major things that are going on during those time periods. There's a couple things I did want to hit, and it's not necessarily a part of the process, but it will help you make your process easier. And it's really bankruptcy no-nos. A lot of people will come in and they're not really sure what they can and can't do before the bankruptcy. And I just want to hit a few highlights just to make sure you don't put yourself in a more difficult situation. Number one, you do not want to transfer any property as you're contemplating bankruptcy. It's a little difficult to go into detail why, but the bottom line is a lot of times things that you think might not be protected are. If you transfer them, they become unprotected. Number two, if you transfer any value or equity that otherwise is not protected, it doesn't necessarily protect it by giving it to somebody else, and the court can go and get it back. So it doesn't really do you any advantage. So stay away from transfer of any value until you talk to the attorney and see if it's something that won't create a problem in your case. The second thing is you want to stop using the credit. If you know you can't afford to repay the debt, you've got to stop repaying it, because at that point you realize that you don't have the ability to repay, and it starts to transfer into a category. And don't be alarmed by the phrase where it's fraud, because you're taking out the debt knowing you fully can't repay it. Number one. Number two, when you're taking out debt closer to the eve of the filing of the bankruptcy, it creates other issues, depending on what type of debt it is, how you're taking it out. So the bottom line is you've got to stop using the debt when you know you can't repay it and you know you're heading down the bankruptcy road. Go in, see the attorney. Any good attorney is basically going to tell you to stop paying the debt and start referring all the calls over to them. That's what we do. Going back to how do you pick an attorney? If they're not going to take the calls for you, then the bottom line is you're not getting your value. So come see us if you're looking for an attorney. We're going to tell you to stop paying the debt and refer them over to us as long as you are a bankruptcy candidate. There's two other issues, and they kind of go without saying, but I do want to hit them. And one's a difficult issue. Nobody wants to not tell the truth, but the bottom line is you've got to fully disclose in the process. You've got to fully disclose to your attorney, and you've got to fully disclose to the court. So please fully disclose any assets. If you've got any assets at all, discuss it with your attorney. If it's a problem, if you've got a good attorney, he's going to fix it. He's going to fix the problem. He's going to tell you how to navigate it. But the bottom line is you've got to disclose, number one, and number two, no hiding assets. I mean, they kind of go together. You've got to put them all out there. So basically, that gives you kind of a highlight of the process. I want to end on an up note, because the goal here of the whole process is to get to recovery, to get your credit back, to get to the point where you're beyond the bad debt that's put you into bankruptcy, and your credit's rebuilding and your life's moving ahead to a much better financial future. Bankruptcy really is just a patch. It's a patch that you need to get down the road of recovery, but it's an important patch. And it's important that you pick the right attorney, that you find one that's interested in your case, that you find one that will work with you on payment plans, will take as much stress off of you as possible, and will guide you with good, clear lists of what you need to do and how you need to do it. So pick your attorney wisely and you will be very successful. But make sure, above all, that attorney has an emphasis on recovery, because if they do not have an emphasis on recovery, you're only patching a tire that's ultimately going to start leaking again.